All right, so I'm looking forward to this panel to wrap us off here. We are going to talk about the changes in IP law that changed everything. And we have a panel that includes leaders in several firms here in Cleveland in the intellectual property practice, and we also have an independent inventor. And so I wanted to start with this discussion. Karl and Kip are going to talk through some of the experiences of being an independent inventor and going through some of these changes before we hop in and get the opinion of all of these experts in intellectual property law. So I'll let Karl and Kip take it away.
Yeah, that's exactly right. We're going to tell these guys how this scheme of enforcing intellectual property has gotten so screwed up, and we've departed in this country from a celebration of independent inventors who can come up with an idea, contribute good ideas to society, and be fairly rewarded to a system where that's really difficult and somewhat antagonistic. So I'm Karl Maersch. I'm a patent attorney located in Chagrin Falls, Ohio. This is my client and friend, Kip Azzoni Doyle.
Currently working on a musical called IPR, the musical.
Kip, that's not funny.
It's not funny.
I know.
It's a tough audience.
It's a tragedy. It's a tragedy. So Kip has 3 patents directed to a case that allows you, that protects your personal electronic device and also has a slot for credit cards or your ID or anything. And so Kip came up with this idea a number of years ago, and she's been through a couple iterations. This is her latest product. This just came out a couple days ago, and it's actually carbon fiber. Super cool. This is a subject of another patent. She's not done with the patent system. She's filing more patents, but it's called Card Shark, and it's got the shark back, as you can see, and it's got a serrated edge, and it's really kind of cool. But that's a little bit of the cart before the horse. Let's tell the story about how we got here. So I started representing Kip probably 3 or 4 years ago, and I was her 3rd lawyer. And Kip came to me through a mutual friend here in Cleveland who had helped Kip do some licensing deals. And so I got to know Kip, and as we got more and more into this licensing program, the world started to change with respect to various aspects of patent law, and it changed the way Kip made money from her patents and changed the way, frankly, infringers reacted to Kip. So let's start first with, how'd you come up with this idea?
First of all, thank you. Thanks all for having me, an independent inventor, with you all. Some of the conversations this morning were most interesting, and especially about financing and stuff. And anyway, I came at this as a single mom, 4 kids. So I was raising these kids, and I had this idea. I was out on my motorcycle just one day, and I was thinking, as I was pumping gas, I had to get up, I had to get my gear off, my helmet and my gloves and my key out of the ignition, put it in the seat, pop the seat, get my wallet, get it out, put my credit card in to gas up. Versus, I can leave all my gear on, I can have everything, I can just sit on my bike, check my phone, a BlackBerry at the time, and just punch my credit card in and be gone. So that was really the first aha moment. So when your panel was talking about what kept you up at night, for me, what kept me up at night were the inventions. The name of the product, at first I thought, oh, stealth would be a good name for this. And then I thought, well, and then in the middle of the night, I woke up and wrote down Card Shark. And then the next morning was like, what is that? So for me, the night is when actually I had those aha moments, but based on this one motorcycle ride.
So you get 3 patents, and then after you got your patents, you decided to start building a product. So how'd that go?
The 3 patents part, you skirted over that pretty quick. The 3 patents part was quite a process in and of itself, finding a legal firm in New York City. Pretty big deal for me, didn't have any idea. But I decided that the way I could monetize this would obviously to be manufacturing my own version of my own patents. So I found a partner who, and I didn't know anything, and I still don't know much, but I gave him quite a bit of percentage of the company because I thought, okay, well, he's going to bring the whole manufacturing side. He's going to know that. I know what I know, and I know what I don't know. So let's turn to those who know. So I got this partner, gave him a percentage, and he came up with a silicone version of the case. I think the first patent was the back of the phone acted as the back of the wallet. So it was basically a slit in the case, glorified a bit, but it was a silicone version, which wasn't really particularly skinny jean friendly, or all these things that you had to kind of think about, like it would stick. And so there were elements that just it was never exactly what I wanted. So after a few iterations, we arrive at what I think is a pretty cool, slick, has all these antimicrobial whatever, but it's slick and it's elegant and it's resistant and you can drop it.
Well, in this one, you've learned a lot on this one, because obviously, but like the first one, why? That's a common way for U.S. inventors to get a patent and start manufacturing product.
Yeah.
What's the big limitation? What was the limitation back there?
Good question, and I didn't answer it right. So I got this partner. I thought, okay,
I'm not taking your deposition. You just say what you say.
The hard part was I was just a single human being with a good idea, but I didn't have I couldn't, I was going to the Apples, I was going to I think at that time, BlackBerry, and everybody was like raving about it, but I had no way of actually entering that market space. I had no idea how. I didn't have distribution, I didn't have a sales channel, I didn't have, and oh, by the way, there was no social media back in the day, so there was none of that, you've got to have influencers and all this stuff. So anyway, it was really hard for me to break into any box store, let alone any big box stores or any of those sales channels.
So freak out the students in the room and tell them which iPhone model was the first one you made a case for.
You guys weren't alive. Wait, what are we at now? 14 as of yesterday or whatever.
Yeah.
iPhone 3. But even more throwback, is it Thursday? Well, the first designs we did are for the BlackBerry, because back in the day, it was all about the BlackBerry. So.
And you guys, and what's funny too, as representing KIP and trying to assert patents against people, we have seen every piece of prior art that even comes close to anything, and nothing comes close. But back in the time when KIP came up with this invention, everyone was carrying BlackBerries, and there were no cases on BlackBerries.
They were dinosaurs.
They're indestructible. You could hammer a nail at those things. So no one thought, no one thought to need a case.
No, there was this whole, everybody spun their cases, and then it was like, I heard it from everybody. Well, if you do that, you're going to affect the secondhand value of your case. I'm like, it's a phone, guys. But they did all these different, I don't want to scratch it and this and that. I'm like, well, that's why you need a case.
Yeah.
Anyway.
So distribution was an issue, obviously, because it's hard for an independent inventor, whatever. You guys, you don't need me to talk about that. So you switched to a licensing model. And you've licensed, back in the day, there were several large manufacturers that, sold these things. And you licensed two of the biggest ones that I know of. Who are they?
Spec, awesome company. And Casemate, an interesting company.
What KIP said, and the other thing is we have a list of licensees that's as long as my arm, but everyone wants a confidentiality provision. So we every once in a while I'll get somebody, every time I sign up a deal, I'm like, can we not be confidential because you got a good brand and I'd like to tell the world that we have a license from you, and nobody wants to do that. But it is funny when you mention a name to KIP, the reaction she gets depends on how much money they paid us. And if they paid us crap, she's like, I hate that company. But Casemate, Casemate's great.
Casemate's the other reason why I was a little, if I'm allowed to tell the story of walking past the billboard.
Sure, go ahead.
My daughter, actually, because I have 4 kids, and at the age when they were growing up through this, the best demographics you could ever ask for. And none of these phone case companies ever expected that I'd have my little minions out there, one in college going, you're infringing on my mom's patents, another one headed to school, walking down the street in New York City, and I was telling the story, I had opened my kimono to one of these companies, Casemate, and they said, we'll never ever need to look at your IP. We are never going to do anything like that ever because we know everything there is to know about the phone sector and the phone accessory business. Really? And so I said, well, just let it be known that if you do, this letter or this email or whatever it was acts as proof that I got to you, I showed you everything, and you guys have said you aren't going to. Well, they never expected me to come knocking back on the door when my young daughter walking to school goes, Mom, and she took a picture on, I think it was like, her flip phone or whatever. And it was a picture of my credit card phone case on a billboard. And I mean, my mind blew, right? It just went right up there. And then when I finally was able to kind of settle down enough, I realized that it was one of the companies. So yeah, really.
So that's for our panel on trade secret misappropriation and why willful infringement can get you a really big settlement from somebody. But it's a common problem for independent inventors who get under NDA and think that they're doing the right thing and helping find a partner.
The only way you can go forward.
Yeah, and the ethic, I mean, that's a business ethics discussion, but I love it. So we start the licensing model. One of the things that changed in the intellectual property scheme is the availability of IPRs, right? Prior to IPRs, you could sue somebody or not sue them, and their only recourse for challenging the validity of your patents was district court, U.S. district court. So when IPRs became a thing, talk to us about how that changed, how people reacted to our demand letters.
Everything changed. And I was right at the time when I really jumped into this little pool. I mean, it was, I was being offered a really nice big company was offering to buy my patents.
You can't say their name.
I can't, I won't. Okay. I would never do that.
Okay.
No. And anyway, it was exciting, and I was just thrilled. And within 6 months, I think, to a year, I'd say, the IPRs, everything changed, the PTAB, all that stuff that all of us inventors are gonna, but the truth of the matter is it killed any opportunity for us little guys who were trying to enforce our patents or even sell or even find financing. The angels ran for the hills, and friends and family were kind to a limit, but then there's this huge gap. So the whole gap is where most of us, when you talk about startups, I mean, these are real startups. These are like the garage door is closed so you can go to work. We're all really startups. So it's a really difficult thing to hear the discussions about the startups that start at, hundreds of, or tens of millions or a few million. So that all vanished, all of that area of opportunity for people to believe in defending patents. And similarly, the term IPR opened a really difficult way for us to thread the needle, or I say like dance along the mines, because every single time we'll hear, we don't infringe, and then we'll hear, well, we're going to IPR you. And we'd rather spend the money on the IPR than ever pay you a dime.
Yeah, and so that's exactly it, right? And so our licensing model, we're not a litigation avoidance. We're not in there telling you should pay us what you'd spend in litigation. We're in there getting you under NDA and saying, we have an established royalty rate based on your sales. This is, what we typically would get for a license, for this technology. And we offer fully paid up, and we offer, running royalty, whatever anybody wants to do. But once IPRs started and then started becoming in vogue, it's hard for us to get a settlement out of anyone, irrespective of what their sales are, for any more than $1 less, and often a lot less than what they would pay for an IPR. Pennies. Yeah, right.
Well, anything under the number. I mean, let's just be really honest here. So say it's going to be $135,000 to IPR you. We'll come in. We have to come in with a number below that, always. Yeah. And it's way below that, or they call it a nuisance fee.
Or often what they do is they actually, whatever the cost of an IPR is, they'll say, for what it would cost us to get an IPR on file, which is the thing. But anyway, Kip and I could talk for 8 hours on all of this, so I'll move to the next topic, which is TC Heartland also changed our life. Kip is from New York. Strange small world story from last night that we discovered. Laura Quatella, keynote speaker, my former boss at Kodak. Kip Azzoni Doyle, my friend and client, and myself were born in the same hospital on Long Island, New York.
That's weird.
Kip's from New York. Kip has a lot of connections in New York. And Kip's company, her LLC, is based in New York City. So for years, we would sue people in New York, in the Southern District of New York. We had a law firm there. Everyone knew the drill. TC Heartland comes through, and I'm not even sure you know why that changed, but you just knew that it changed.
Oh, I did know a little bit. I don't know much, but I know enough that when it affects you on Christmas Eve, and
Oh, that's a different.
That's not
That's
TC
the different
Heartland,
one. No,
that's not-
TC Heartland is now why we have to sue people.
In
We can only sue
jurisdiction?
people in jurisdictions where they.
That's very
work.
much the story, sorry. It was Christmas Eve, and I was writing a cease and desist letter to a company in Texas. And then they dragged it out, and they wanted to like walk hand in hand, kumbaya. We're going to buy you. We're going to do this. So dump all your information to us. Let's all sign. This is great. We love you. And what it was for them to I guess they were able to have access to all of my information, and therefore at the end of the extended period of time, which just happened to be Christmas Eve that year, they then turned around and said, we're going to sue you because your cease and desist letter was in our jurisdiction. And oh, by the way, you were in Texas and you wrote a book. I was like, I did? So they dug up all this stuff on me. I'm like, I've never been to Texas, but my publisher was in Texas.
Yeah.
So anyway, so I had to then scramble Yellow Pages back. Remember those things? Anyway, and I'm finding a lawyer in Texas, and it was a rocket docket.
Yeah, that was Eastern District. Yeah, and that wasn't a TC Heartland necessarily, but that was absolutely Kip's cease and desist letter and our subsequent settlement discussions conveyed DJ jurisdiction, and we got sued in a court that we didn't really want to be in.
Which they then threw out for frivolous, whatever that term is, but so
Yeah,
they did
but
throw
it
it
took-
out.
but it took motion
oh my
practice.
goodness,
Yeah.
yes it did.
But anyway,
for the
TC
students-
Heartland changed our life because now we have to sue people if we sue them, and we try not to, but sometimes we file complaints, but we can only sue them in certain places, which means we have to hire local counsel, which means Kip has to pay out of pocket because her lawyer doesn't pay for that kind of stuff. Everyone tell her that's normal. Thank you. And so it just complicates our life, and it's another change in the patent system that these guys are going to opine on when Kip and I get done. The biggest change is something that Laura talked about in her keynote that we see, and it's we have a great story, not so great. I wasn't there, but what's the biggest change we've seen?
Yeah, I think the most important thing is just the dignity, and I mean, just restoring, or if there's ever a chance to recognize that once upon a time an inventor was considered to be an important backbone, creation of jobs, kind of an individual who was going to bring growth and innovation, and I think that's just gone out the window, and now I feel like the inventor is the pariah, and I don't think I'm overreacting. I mean, I overreact a lot, but not in this case because it's just really nasty. And Laura, I appreciate what you were saying. You're at a whole different level, but I appreciate when you say that from where you're dealing with people, just dignity and just respect. Respect is all anyone. And so I wrote a little thing, because then I'll be quiet, but
You always say that. You're the star of the show.
I would
I'm
like
here
to
pulling this
finish.
out of you because
No,
it's such a great setup for patent reform.
Okay, well, there was no dignity after. There were no discussions. It was very challenging to be taken seriously or to not be taken advantage of, in a sense. So, and then it was just nasty. And I think, for me, it really isn't. It doesn't matter what you do in life. It only matters. I'm sorry. It matters what you are. And for us independent inventors, and for most of us, I would say, we had an idea, we scraped our money together, we secured our patents, and we poured our heart and our soul and everything we had into this work just to see it come to fruition. And I think all any inventor ever wants is to be treated with the dignity, no different than any lawyer or doctor or teacher or bricklayer. And I think that's no, you're not hurting my feelings, but I think that restoring respect might get us a whole lot farther down the road of recognizing what went into that patent. And I guess if you guys are all students of soon-to-be patent lawyers, it'd be awfully cool to remember that. the backstory, it's interesting to learn. Like, you know, you don't Google everybody all the time. You kind of want to have the discovery, right? You want to meet that person and you want to see what goes into that company. This is a great idea. What goes into this is I hire homeless and at-risk veterans. I'm a woman. None of that matters. None of it matters. They want to IPR me. They want to end this. They want my veterans to go back on the street. I sit and I say that, and I'm just whining. And it's just not, to me, that's...
You guys, it's crazy the reaction we get. And it's one thing to have your lawyer, like, come at me, because I don't care, I do that. But when I set up a business-to-business discussion with legitimate companies, you know, on the other side, and they come across the table at KIP and they threaten her and they try to intimidate her, it is like the most embarrassing, like comically shocking thing that I've seen. And it's just, it happens all the time. And we actually weren't going to talk too much about this until Laura's in this discussion today about, you know, the civility of it. And it's really, it's really been shocking for me, and I'm kind of an a-hole. So, so to close this all off, Kip already mentioned what she's currently working on. We're obviously licensing the patents, and it's fine. I mean, we have some challenges, and it makes it harder, and the economics are quite different for Kip, and it's just a longer process than it used to be. Kip wrote a book about her story, and if you want the extended version of this speech, it's all in there. There were a number of copies out there. I think there's still a handful, so hopefully if you had a chance to grab one. If you didn't and you want one, email me, and I'm happy to get you one, but it's a fascinating story.
It's not my story. It's my story, but it's mostly about other independent inventors who have lost a whole lot more than I have, and I care a lot about them, so I really wanted to get their stories right, because I think that's the key to how this community of, you know, people who have ideas should really band together. So that's what I was trying to do.
So you guys, the goal here was to have 3 esteemed litigators and patent strategists talk about patent reform and how the framework that we all practice law under, whether it's, you know, and the changes came from, you know, whether legislative or cases or what have you, have really shifted in a lot of ways. And I thought it would be interesting to have Kip here and tell her story so you guys could get a real world view of how these things actually have impacted, you know, my client and friend. So that's our little vignette to set up the next panel, which is these guys.
Thank you. And it's so wonderful to hear that story, and interesting that you were able to tie it back into that. Some of the changes are not just changes in substantive law, but changes in practice and also changes in the way that people treat each other. And so I'm hoping that all of you guys as students can listen to this and say, how can I make sure to act with dignity so that doesn't happen when I'm in the room dealing with those types of interactions. But let's go ahead and introduce our panelists. If you wouldn't mind giving a couple sentence intro of who you are, and also thank you to John Cipolla at Calfee for sponsoring as well.
Sure. I'll start. Patrick Norton. I'm a partner at Jones Day, practicing in patent litigation. You know, I've been here all day listening to the talks, and it's been a great conference. Christa, thanks for inviting me. But it's sort of interesting because I feel like we started off in the morning with early stage development companies, and we got all this stuff, and we get to the end of the day, and you failed. You're in litigation now. and how are we going to change the system? So that's a little bit about me.
Hi, I'm Steve Auvil. I'm a partner at Squire, Patton, Boggs here in Cleveland, and thank you, Christa, for inviting me, and look forward to the discussion.
I'm John Cipolla. I'm a partner, head of the IP group at Calfee. Predominantly, most of my career has been an IP litigator, although I've done a lot of other IP stuff. I also went to Cleveland State, and that's why I'm here. Went to night school here back in the mid-'80s, and I went and bought these shorts. I told the people downstairs I would pitch there's a basement down here where they used to put our grades up. And I still have nightmares of that. And it was not confidential. They'd put your name right up there and what your grade was. You see contracts, you go, oh my God. So anyway, I do have a question, but you won't win these shorts if you win. But does anybody know who Mouse McFadden was? Who was he? Who? Yeah, in 1986, for those of you that don't know, Mouse McFadden led the Cleveland State Vikings to the Elite Eight of the NCAA tournament. Almost went to the Final Four, but they lost to David Robinson at Navy. But that was when I was going to law school back in the 80s. So anyway, I had to buy these shorts. So go ahead, Chris.
Great. So thank you guys for your introductions. Kip mentioned a couple of changes in intellectual property law during her time, including IPRs and TC Heartland. Why did some of these changes happen, and sort of what was driving those changes? And then we'll go to some other changes that you guys have noticed as well.
Sure. Well, I guess I'll start. You know, one of the biggest changes in the practice since I've been doing it is the IPR system. And you could challenge patents before, but the re-exam process was long and tedious, and you had less of a likelihood of getting a stay. So the idea behind the IPR process was a quick and efficient way to evaluate patents and get rid of what was perceived to be at the time a lot of bad patents that are out there in the system. And you know, there's been some pros and cons in the IPR process. Obviously, it's not everybody's cup of tea, but for clients that are being sued a lot, and a lot of these patents might not have a lot of merit or validity to them, it provides a way that is less expensive for challenging patents, and you have an opportunity to have that issue tried by the PTAB as opposed to, you know, a jury. So, I mean, I think that's part of what drove that, was a desire to get rid of bad patents. Whether it's gone too far, where the pendulum is on that, is a subject that, you know, reasonable minds can disagree on.
John and Stephen, do you have any thoughts on why those happened?
Sure. The TC Heartland, that was really an issue. The Federal Circuit had decided a case probably 25 years ago that decided that the patent venue statute, interpreting the patent venue statute, that you could sue somebody wherever they reside, and what residing meant was anywhere where they did business, where they sold product into a jurisdiction. And so that was really settled law forever. I mean, it was 20 plus years that no one really challenged it, and then someone challenged it. And it worked its way through the appellate process. The Supreme Court took the case and said, took a very literalist approach to the statute and said, no, what resides means is something more than simply where you do business. You have to. It's a state of incorporation, or it's where a principal place of business. It's not simply a place where you sell a product into. And so that changed a lot. It created a major shift in where litigation was filed. So Eastern District of Texas at the time had about 45% of the cases were filed in the Eastern District of Texas. And after that, very quickly, after the case was decided, the next year it was down to like 20%. And so radical shift. Many cases went to Delaware and other locations where it was easy to secure jurisdiction. So in the Eastern District of Texas, just so it's clear, was considered a very plaintiff-friendly venue. And so that had a significant impact on valuation of cases, because you realize that, hey, I'm not going to get stuck in the Eastern District of Texas where judges really don't, in general, this is a generalization, but believe in the jury system and the jury deciding facts, not judges deciding facts in summary judgment. And so that was T.C. Heartland. IPRs, there was an administrative process prior to IPRs in the Patent Office. They're called reexaminations, and there were an ex parte reexamination and inter partes reexamination. But those were decided by examiners, not IPRs, which are decided by, quote, administrative patent judges. And they took forever. And there were multiple layers of review. So you had a unit in the Patent Office that would decide re-exams, and then you had an appeal to the Board of Appeals, and then you could go to the Federal Circuit, and then if you lost the Federal Circuit. So it was a very long path to the end. And if in the ex parte side, there was not any finality. If you filed a request for examination, the way it was structured, all you could do was essentially file something, and then you were no longer involved. You could challenge the patent, and then you could sit back and see what happened. You could ask a court to stay a case if you were the defendant filing this re-exam request, and say, you should stay the case until this re-exam is decided. And a lot of judges would do that. But they would take forever, and so the cases would stay on the docket. And if the challenger lost, it was not binding on the challenger. So they could lodge another challenge in the district court. And so it was really not a good system. And so the IPR system was designed to have a binding effect. If you challenged and you lost, you were done. The case would go to district court, and you couldn't argue the same thing in district court like you could in the ex parte reexamination process. So that was considered an improvement. Also, the appellate path eliminated the board because it was the board that was deciding, and so the path of review was on to the Federal Circuit. So there were, in theory, there were good reasons for the changes. In practice, it definitely had some challenges, and Karl, you pointed out some of those.
Yeah, I sort of have a more historic view of all these changes that have gone back and forth. I mean, Patrick calls it a pendulum. I started practicing before there was a Federal Circuit, so. Back before then, the whole advent of the Federal Circuit was to really strengthen our patent system. Back then, every circuit decided the patent laws differently. There were more favorable circuits than other circuits. There were some circuits that never, I forget what it was, the Fifth Circuit or something, never found a patent valid. So if you were a defendant, you wanted to file a DJ action there because you're going to invalidate the patent every time. So they invented the Federal Circuit, which was supposed to be the Supreme Court of patent law in the United States, and it did strengthen patents. And it did create this one court that theoretically was supposed to, rule very consistently on all the issues. And we wanted a stronger patent system at that time. I think it was like 1987, 1982. And so we had this strong patent system, and then along came the advent of the non-practicing entity, AKA trolls, okay? Let's call them what everybody called them was trolls, and then they came up with non-practicing entities. And there was a firm up in Chicago whom I litigated against many times that has names ending in vowels like mine, named Nairo Scavone, who I litigated against many times. That was the most famous patent NPE firm and really started that whole industry. And they had a client named Jerome Lemelson, who I've also litigated against, and some of those lawyers got so, let's just say, rich as a result of representing Jerome Lemelson in all of these non-practicing entity suits that they flew around the United States and the world in MiG jets that they bought off the Soviet government. So everybody, these patent laws, are 1952 was the last time the patent law changed before the most recent AIA came about, which was like about 60, 70 years later, but everybody threw their arms up. These patent trolls are killing business. They're a cost on our business. We've got to do something. Our patent system's too strong. They're getting these patents and they're not even adding to the economy. They're just going around causing litigation, and they're making money off of us and not adding anything to the system. So then there were a bunch of lobbyists for a lot of big companies that started, raising this hue and cry. And I do represent a lot of big companies too, but, and that's what really started the evolution of the patent laws, both in the court system, because the court system wanted to try to change it as well, and the legislature came up with the American Invents Act. And the American Invents Act created the IPRs, and everybody, the ex parte re-exam system that Steve talked about, everybody sort of wanted to get their patent. If you owned a patent, you might even file an ex parte re-exam with your own patent to get it re-examined, because it would strengthen that patent in litigation. You could go then to the jury and say, look, I've been to the patent office 3 times with a re-examined patent, and they blessed that patent. You should, nail me. So give me tons of money for that. And those companies didn't like that, so they created IPRs, because what happens was it was viewed to be an easier forum. When you go in the patent office, once you filed this ex parte re-exam, then you were no longer involved, and getting it through the patent office is viewed to be easier, because you're dealing with the examiners and the PTO, and then the other side doesn't have any word in it. The person that's trying to defeat the patent doesn't get to depose the people that filed declarations in the ex parte re-exam, or stand up, and like our normal legal system, there's one side and the other side. You don't have that in the ex parte. So that's what the whole theory of the IPR was, is let's give that other side some ammunition to fight against this, and we'll come up with a fairer result, and we'll defeat some of these patents that were weak and were being wielded by these trolls, okay? And so it was designed to be in the AIA, all good intentions. It was supposed to be a very streamlined procedure. Each side would file one brief, one expert, one deposition, be relatively cheap, be fast for inventors, be done quickly. Well, and it was supposed to eliminate or reduce litigation, because you fight in those IPRs, and it'd be a lot cheaper to do and quicker to do. And as it turns out, in my view, that IPRs really multiplied litigation, because what happens is, and they're not streamlined, because there were really not a lot of rules in there, and you got a lot of judges that are on the PTAB, which is the Patent Trial and Appeal Board, that really weren't judges. They're old litigators like us that then go to the patent office, and there's not a lot of rules, and everybody's filing many briefs, taking many depositions, filing many declarations, and it never ends, or it's a lot more expensive of a process than it was ever intended to be. It doesn't have the estoppel effect. People started arguing that, eating away at that. It's supposed to be over there, but it's really not, because then everybody starts arguing, nibbling at the edges of that. And meanwhile, if I'm representing someone that's having their patent reevaluated in an IPR process, and everybody does this, I'm filing like 2 or 3 more patents where I'm writing the claims on the product a lot narrower to avoid the prior art that's in the present IPR, and then 3 more IPRs get filed. And I'll file another lawsuit. So you end up sometimes with 3 lawsuits, 6 IPRs, and it's just multiplied litigation. Now, it's good for our businesses, but I don't think it's done what it's intended to do, okay? So, and then there's all these, like TC Heartland really is just, it prevents, and it hurts. We represent a lot of, we're in the industrial heartland. I represent a lot of manufacturers, okay? And they have patent portfolios, and they protect the products they make. And I was able to sue, or were able to sue in their home court, because the stream of commerce theory would allow you to sue anywhere that infringing product was. You were able to have personal jurisdiction. Well, TC Heartland changed that, where you have to sue the defendant in their home courts, or where they have a physical place of business, is what it's called. And so you have to go sue in their home court, and it not only hurts independent inventors, and we represent a lot of independent inventors as well. I represent one guy that makes gloves for eating chicken wings, believe it or not. But anyway, and I've represented him for like 15 years. Awesome. But anyway,
get me some of that.
so so that really hurts these smaller, the industrial heartland type companies, because I used to sue a lot of people in Cleveland, a lot of people in Northern District of Ohio, Southern District of Ohio, and now I can't do that anymore, and it hurts. Okay, and so what's happened with all these with all these changes is, I feel the pendulum, even though I represent a lot of defendants, has swung. I mean, I represent both sides. We all represent both sides. It's swung against the plaintiffs. The patent system and patents are weakened in this country than they were definitely 10 years ago. And I don't know what the effects are ultimately going to be of that. Probably the pendulum will swing back, but it gets a lot tougher for plaintiffs and patent suits. There's a whole heck of a lot of other changes, but I've spouted off too much, so let you guys know.
I will add, it's not just conscious changes from Congress where these things happen.
Right.
It's changes from courts as well.
Right.
That may be conscious policy decisions, but more often are sometimes just legal interpretive decisions that have unintended policy consequences. You mentioned estoppel, for example. The scope of IPR estoppel is an issue that's going to be potentially coming up to the Supreme Court soon. There was a cert petition filed by Apple in that case. So we might see another shift in how IPRs are handled. And again, not all of it from a conscious policy choice. So all three of you have had...
Real quick,
Yeah,
I would
please.
just comment to John. Part of what you're talking about is what happens when you have lawyers. Of course we're going to...
I totally agree. I totally agree, Patrick.
Arguing on things and, chip away at the edges of things. So, yeah, things evolve over time. But go ahead.
Oh, I was going to say, well, all three of you have extensive experience over decades of practice. And we've talked about the creation of the Federal Circuit in 1982. We talked about the America Invents Act in 2011, the creation of IPRs. But what are some of the most significant changes in your experience throughout your careers, and how did it affect your practice? Maybe we can start again with Patrick and go this way.
Sure. Yeah, well, I think probably since I've been practicing, which is about 25 years, the American Invents Act and the IPRs probably was as big a change, in the substantive law as, that happened during my time. The sort of a bigger picture, though, and this sort of is where we fit in, IP law as part of law and society in general, the cost of litigation has just exploded as data and email. I mean, I was joking with somebody at lunch, and they were talking about how when they had a case early on, the other side buried them in 30,000 documents, 30,000 pages of paper. This was 40 years ago. But, you used to get paper copies of the other side's production and review them. You can't do that anymore. I mean, it's terabytes of data. You need servers, and you have to search through it. And it costs money to collect. It costs money to review, to search, privilege, relevance, all of that. And then at the end of all that, you have an enormous database, and none of the lawyers who are actually working on the case know what are in those documents, because none of them have looked at any of it. So that to me is a big issue. I think it ties in with some of these larger issues that we're talking about, but to me the cost of litigation is a big change.
And I will add one interjection for students is that if you can become an expert in e-discovery and you're willing to go in and dig into those documents and you're the only one on the team that knows what's in those 4 terabytes, you're going to get a lot more exposure and experience on the case than the other people who are saying, I don't want to work on document discovery, I'm here to take depositions, right? Well, the person who's going to be able to take those depositions is the one that's dug into the discovery.
Well, just to follow up on that point for the law students in the group, and I will reveal a little bit of my age, on this. First case I worked on, one of the first cases I worked on at Jones Day, I was the junior associate, the new associate on it, and my job was going through, all of the actual physical boxes of documents. And nobody in the team knew the documents the way I did. Well, that case went through discovery, went to trial, went up to the federal circuit, was reversed, came back down, and when it went back to trial the second time, I got to try it because, with Cal and Karl was there. But there's a case where you're the junior associate doing the boring work of reviewing the documents, but it winds up maybe with an opportunity for you to have a stand-up role, whether it be in a hearing or a trial, taking a witness, because you are the person who knows the documents, the facts, where the bodies are buried, where all of the good nuggets are.
I had a similar experience where I worked on a case for 7 years. We were defending a class action, and when we started, it was a small team, and I was the only one reviewing the documents, and so and reading sort of the background studies and things like that. So when we finally got up 7 years later, I was the one that got to prep the experts, and I got to take the lead plaintiff deposition, and it was great. So that's an experience you don't get to have unless you're building that foundation and knowing the materials. So anyway.
Yeah, so I want to build on that too. I think beyond that, knowing the documents, understanding what relevance is, understanding a document, is it useful to prove some fact that's going to be in dispute? How do I get it into evidence? How do I keep it out? All those decisions are tremendously important as cases progress, and you start to figure out, like, how am I going to prove my case, or if you're the plaintiff, how am I going to prove infringement? How am I going to prove my theory of damages? If I'm the defendant, how do I prove a certain defense? And so knowing the rules of civil procedure, the rules of evidence, and constantly thinking about documents in that way is extremely valuable. I wish somebody would have sat me down early on and had that discussion with me. Back to your question, Christa, about changes. By the way, Patrick, John, and I, and Karl were all kind of earned our stripes at Jones Day. Some of us were smarter than others in terms of moving on to different things. Only kidding. But when I first started practicing, I was a privilege log lawyer. I used to think of myself that way. I would review documents, add them to the privilege log, and know all the privilege log cases across the country going back to the 1950s. It was not the most rewarding work at times, but I felt like it was a great foundational thing for my career. But at that time, when there was no such thing as a claim construction hearing, the Markman case that the Supreme Court said that the meaning and scope of claims is something for the court to decide, not a jury. It used to be back in the day, everything got submitted to the jury. Your theory of infringement just got submitted to the jury unless it was taken away by the judge. It was so absurd that you weren't entitled to a jury trial. So Markman and the aftermath of that, the birth of the claim construction hearing, and it's a trial before the trial. and it's extremely important, the outcome of claim construction hearings, the Markman order, so-called Markman order, a lot of times is outcome determinative, and so that was a major change. And the second one I'll mention, there are a lot of them, but the eBay case, which took up the question really whether patent law was special when it comes to determining whether injunctive relief is appropriate or not. It used to be there was this judge-made rule of a presumption that an injunction should be awarded if you could establish infringement and avoid a finding of invalidity. eBay said, patent law, you're not special, and it essentially wiped away the presumption. And so in every case, you have to prove as a patent owner, if you win the infringement case, you avoid invalidity, that you meet the requirements of the general requirements. You've established success on the merits, irreparable harm, that you've been irreparably harmed in some way. And that's the big one, irreparable harm. If you're a so-called patent troll or non-practicing entity, it's impossible. It's almost impossible to prove that. And so that case had a dramatic shift, or had a dramatic impact, including, we didn't mention this in the venue context, but the ITC, which decides, it's a trade related administrative agency, has a remedy available to patent owners against imports. It's directed toward imports of infringing products. In the ITC, you don't have to show that you meet the eBay requirements. If you prove an infringement, you get the remedy. You get the remedy of an injunction, essentially an injunction exclusion order is what it's called. And so that eBay was great for ITC lawyers, absolutely great for ITC lawyers. And so so cases moved out of district courts into the ITC, and that whole venue exploded. So
That's helpful. I will add one point about the ITC for students that don't know. It's an interesting place to practice because you can get very rapid experience. So if you end up going into litigation and you do some work in the ITC, these cases, sometimes you'll be doing the type of trial prep that you would do over years in a district court, you'd be doing over 6 months. And that can lead to very rapid experience for junior associates.
Yeah, and the judges there are it's specialized. I mean, it's a rapid hearing and procedure, and everybody's really working really hard. But the judges also, really promote having young people do witnesses and do all kinds of litigation things that you wouldn't see it. I was an associate at Jones Day for 20 years. No,
Depends on how good you are.
that's how many. That's
right.
They
You're
let
right,
you do stuff
Patrick.
right away.
You're right, Patrick.
You got 20 years of experience. You only worked there for 2 years.
Right. Well, I was there for 4 years, and about 2 of the years was doing privilege laws, which, Steve, that brings back great memories. But no, you do learn a lot about privilege law, and you learn how to get very creative on those privilege calls as well. But anyway, there have been many changes, I guess, for the students. I mean, this the evolution and the changes that go on that have occurred over the last 35 years since I've been involved with this has been crazy. You got to constantly be paying attention and doing that legal research and paying attention to what the Federal Circuit's saying and reading the blurs, because it changes, daily. I mean, there's changes to willful infringement, inequitable conduct. I think inequitable conduct has changed probably like 4 or 5 times since I've been practicing, how you prove it, whether, what the standard of fraud is, whether there's a sliding scale of materiality and intent, or whether you got to prove actual fraud. I mean, it's changed quite a bit, but you really have to pay attention. But overall, I think, just like I said before, I think most of the changes have favor the defendant if you add them all up, I think, the patentee and the plaintiffs have it a lot harder than when I started, for sure, so, anyway.
So that brings us back to another question is, with these changes going, as you said, there's a pendulum sometimes. Where are some of the places where the pendulum is starting to swing back in the other direction?
Well, I know they already don't agree with me on it, but I think it has swung back a little bit on the IPR front, because I think that, so we set up these systems that don't necessarily have the best incentives. We create a new agency effectively and get all these new judges in the PTAB to try all these cases, and they have nothing to do if they don't accept the petition and review all the patents. So right away when the IPRs first came out, and it's a little bit of the timing issue, for Kip and Karl and their situation, is when IPRs went live, everybody was, if you were in a lawsuit or litigation or being threatened, you went and filed, and they had no cases. So 96, 97% of the petitions were granted, and then they reviewed them. And they knocked out a lot of patents. And then they got busy, and they had more work than they knew what to do with. So they started denying petitions, so the acceptance rate has gone down. Then they started coming up with ways to discretionarily deny the petition without even passing on the merits. Just, you're in litigation, which most of them, if not all of them, are in litigation. You're in litigation, and that judge hasn't stayed the case, so we're just going to deny your petition. So that goes a little bit to some of what John was talking about in terms of the inefficiencies of it. But I think that the pendulum on the IPRs has swung back a little bit the other way already.
Do others have these?
Yeah, I think initially the institution rate was very high, and the expectation was that it would be lower than the rate that ex parte reexaminations, inter partes reexaminations, which had a different legal standard, was considered to be a softer standard. Rates of institution of reexams were very high, 90, 95%, and for IPRs, it's essentially more likely than not that you're going to prevail with the evidence that you put forward in your petition. And that was thought to be, significantly higher, but in reality, it was not the way it was applied. Now, some people would say, well, I think this is your point, Patrick, that early on there were a lot of bad patents out there that needed to be flushed out of the system, so-called bad patents. And so that could explain the high institution rate and the high success rate for petitions. But my view is what I saw I saw an institution in the patent office that thought, hey, we really got something here. This could go really big. And I remember at one of the AIPLA meetings where the leaders of the Patent Trial and Appeal Board were out talking about how they were the leading patent venue in the country for challenging patents. And I remember thinking, this doesn't sound right. That's not. You shouldn't be advertising that it just seemed like they had become like the Eastern District of Texas, but in a different way. Like, bring your challenges here. We'll kill your patents
The
here.
Death Star.
In fact, they call them the patent killers.
They call it the Death Squad.
Well, yeah, and so it was interesting, and it happened to be a conference where Judge Rader was famously quoted referring to the PTAB as the Death Squad, the patent Death Squad, which, and by the way, a little inside baseball, that was actually coined by somebody else who I was having dinner with the night before the judge said that, who used that expression, told the judge that, and the judge repeated it. so he gets credit for it. But it
Didn't
would
trademark
raise,
it.
yeah, exactly, yeah. But it raised a fair point. It was like, what's going on here? What is going on here? And it did kind of I think the PTAB kind of then just became really maybe made itself bigger than it may have otherwise been, and had I think had some unintended policy effects. So.
What about you, John?
What's the question?
The question is,
I
I think how has the pendulum swung back in the other direction?
Well, I think we have some government relations people that work in our firm, and one of them, the person that he used to work for in the government was Rob Stivers, actually of Ohio, House of Representatives, and Stivers was very involved with both the AIA and changes to IP law, and fielded all the various lobbyists from, big pharma, big tech. Those are normally, they're sort of against each other on whether patent law should be strong or weak, and they pump a lot of money into it. But he keeps us abreast on the changes, and I do think that 101 is, there's a movement within the legislature to really clarify what if it can be clarified. My own personal view is that what's patentable or not is very subjective, and that can change with the public policy of the times. If you want less patents, you can find something to be invalid under 101. If you want more patents, you can find it to be invalid under 101. I mean, it's a very subjective test, and but I think they're trying to clarify that. I mean, there's the one case, they found that something was unpatentable, and it was an axle, or recently. I've not read that case, but so that area, I really do think there's a movement afoot to strengthen our patent system. I mean, with all what's going on in the world and the countries becoming more nationalistic, I think there's some movement ahead to try to make our patent system stronger. We'll see if it happens.
So if others have commentary, he mentioned some of these future changes, something like 101. Are there other future changes that you see on the horizon?
One of the things that actually came up to mind, it was something that I thought about after we had our sort of pre-call, when I was listening to Kip and her story, and I don't know if people know this, maybe John, from the government relations person. Right now, the government has out for public comment on doing a patent small claims court. So if you don't have, and basically the comment is, give us your thoughts on these. How much should there be a threshold for what it is? What sort of discovery would we have? Some sort of streamlined process whereby people can adjudicate things. If you are a solo inventor or somebody who doesn't want to spend $500,000 or $1 million, just to get to the starting line in a situation. It was an interesting thing to me that I thought was,
some other big changes. I mean, we didn't talk about this in our pre-session, is Amazon. Selling things on Amazon has become so important. Amazon has its own, in fact, they have patent lawyers that are involved, that work for Amazon, that if you complain about someone, that you can file a complaint. And Brad Liu, who's my partner, who's been involved with many of these Amazon takedown situations, both offensive and defensive, where you really don't even go to the court. You go to Amazon, and if you get the product taken down by filing a complaint with them, that's almost much better than even using our court system. And they'll seize money. One of our clients got, $12 million seized at one point, wrongfully, which we got back, but by someone filing a complaint with Amazon. Yes. They actually have like a system for patents and trademarks where if you point out an infringement, you believe there's an infringement there, they'll pull it down. and before the other side even gets heard. I mean, in other words, I mean,
Accelerated.
it's accelerated, and there's no, it's like a preliminary injunction, expedited, and yank it down. Then you got to fight and argue and go talk to the other side and cajole them and try to get it put back up and try to explain why it's not an infringement. But Amazon's not always that responsive to the person that's in the defendant's place. It doesn't happen as quickly as you'd like.
It looks like, Kip, do you have any experience dealing with Amazon?
No, I was going to ask a question. I mean, it's a really interesting, and there are a couple of companies, I think Red Points, or there are a bunch of companies that are trying to do this to protect if you upload your product or any iteration of your product or patents or whatever, they can scan with AI or whatever they find them across the web and such. But what are the costs to having that layer of protection if you are on Amazon? Because I think for someone like an independent, is it something that's prohibitively expensive?
Well, you have a registered trademark or a patent, and it's really not prohibitively expensive. You file this complaint with Amazon and say that it's an infringement, and they'll have their lawyers or internally look at it. It might not even be lawyers, sometimes it might be just the buyer or
really
someone on there that works for them that says, oh yeah, that looks similar, and pulls it down. Then they worry about everything later.
Yeah.
We've looked into it. The issue, there's a bunch of issues with it. One of it is Amazon's a little bit judge and jury. But the other thing is it's designed for companies that you can't sue. So a lot of the people that we go after are legitimate companies. And the other thing about Amazon is once you get into that, those companies shut down and go around, and you see the same thing with another made-up brand. So it's a great idea, and I welcome it. I do agree with you that it's plaintiff. It's a pendulum that it's a lever that popped up that is plaintiff-friendly, but it has its limitations. And I think it's really designed for counterfeit and trademark infringement, and they do a patent thing, but it's for companies that don't have you couldn't sue them otherwise. And I had to answer that because Kip was looking at me like, why don't we do this? What are we doing?
I figured that.
I've been approached by a lot of different companies that claim to do that, but it's so cost prohibitive anyway.
So on the legislative side, I'm not very hopeful to see any reforms anytime soon. I think 101 is I'm not very sanguine about Congress being able to reconcile the different viewpoints of technology and big pharma. So I think and the Supreme Court has seemingly no interest in trying to produce a better test than what we have right now. So that I don't leave you with a kind of a downer. I do, however, think that litigation finance has been a game changer for plaintiffs. It doesn't fit every case. It doesn't fit the small case, the really small case where an injustice has been done, the damages aren't big. Litigation funders, they're different sizes for sure, but the very small cases, not really very useful. But there are a lot of cases out there that wouldn't have been brought 10 years ago or 5 years ago, but for litigation finance. It's expensive money for sure, but it's a way to get justice, to get paid. And I think that's been a very positive development for patent owners.
Great, so we have a couple more minutes. I wanted to close it off with a question that Karl came up with on our pre-call, which is if you had a magic wand, what would you change about our patent system or patent laws or patent practice? Maybe we can start with Karl on that and go this way.
I didn't want to answer
I would love to know your answer, though, if you have one.
Here.
I think my magic wand might be taking what Steve said earlier. I think that we have put so many procedural trapdoors. Oh God, I just made eye contact with Laura, and she wants me to say we need to go back to civility. This needs to be a gentleman's game, and she's absolutely right about that. But I was sort of in the frame mind of trial lawyer. There's so many trapdoors that we put into the process of of asserting a patent or even engaging in a licensing discussion that are designed for defendants to get out of it. And because I'm sitting next to one of my independent inventor clients, I think broadly, I think getting back to a system that's more trying the case would be advantageous for us. Getting markmen, compartmentalized, and sort of making it more of a, I guess more of a gentleman's game is probably not a bad description of it, but just more of a holistic inquiry into, the patent infringement and not so much procedural. That would be my magic wand, which is probably fanciful, but.
I'll sort of build on that. I mean, the whole IPR reexamination has become, Steve and I, when we were preparing for this, we relayed the story. I mean, we both have patents that have beaten the IPR. They haven't been instituted, and then the other side files a reexam, or someone does, because you can file those anonymously, and then your patent gets reexamined. So, I mean, there's so many bites at the apple. And the way the IPR was intended, if it was a streamlined, relatively cheap procedure where you really just had one expert, one deposition, one brief, and the decision was rendered quickly, and there was estoppel that was ironclad, and you had one bite at the apple, that would be great. But we need to go back to that, I believe so.
Yeah, I agree with that. I think there's some abuses in the system that need to be fixed for sure. And again, I'm on both sides of the V. The other thing I would say is I think the eBay case is bad policy. I think having an evidentiary presumption that aligns with what really the patent system is designed for is, that you have the exclusive, you have the right to exclude others. That's the very essence of the right that a patent holder gets, the right to exclude others from making, using, selling, importing your invention. And the law should reflect that. It doesn't. And so that should change. And on the point of, I'll mention on civility, this is an advertisement of sorts for me, but civility is extremely important. I think if we're together, we're on opposite sides of the case. Patrick and I, or John and I, or Karl, or Christa, or others. We know each other. We've broken bread together. We've had glasses of wine together. In the case of John and I, we've dressed up as in costumes together and made fools of ourselves together, right, John?
Right, absolutely.
And so
Scooby-Doo here.
Yeah, and that's extremely important. The civility that we created an inn of court. Very proud of here in Cleveland, the Kathleen O'Malley American Inn of Court. And that's part of the mission of our inn is to foster civility among the lawyers, professionalism, so that we're better in the court when we address each other, and when we address the court, we address jurors. We're better versions of ourselves. So that's really important.
I agree. Civility also reduces the cost, so.
It does.
If you, I'm telling you that much, so.
Yeah, I would definitely join all those sentiments. In terms of the magic wand question, depending on when I have the magic wand, if I have it after Steve, I would magically wave eBay back after he eliminated it.
And he would lower the bar for recovery attorney's fees against plaintiffs.
Well, I think we've got an issue with non-practicing entities, because I think that's what really drove the eBay decision. And I don't think non-practicing entities should be able to get an injunction. We were talking earlier about blackberries, and blackberries are gone. But there was a big case, RIM, the company that made blackberries. They got hit with a $26 million verdict by an MPE that didn't make a product. and they were going to be enjoined, so they had to pay $650 million on a $26 million verdict. So the lawyers made out really well on that, and the company that actually made a product that they were selling didn't. Yeah, it infringed, and they were going to pay, but I don't agree with that. But I do agree with the disagreeing in a agreeable manner. So, in terms of one other thing, a serious note that I wish if I could change in the system, it would be, and it sort of echoes back to something I think Jason said earlier this morning. We have a lot of judges who don't like patent cases. I would like to try cases to judges who do like patent cases and are willing to pay attention to them, read the briefs, read the patents. And Jason said it earlier this morning, and it sort of struck me, is it's really not that hard if you put in the time. My rule of thumb is if I can understand it, anybody can. And these judges should be able to get it. It's not that hard. We've got experts who are explaining it to them. And I want judges who want patent cases to try our cases. I think we'll get better results
Well,
for plaintiffs and defendants, both.
well, thank you so much to our panelists. And I want to know, Kip, do you have any a final closing note or?
My magic wand would be whirling, but I just want to say, from somebody who doesn't know, and as a layman, because you guys are all, this is your expertise, but I think once upon a time, the United States was #1 in the world for patent, in the patent space, and now I think we're down to 12 with Italy. I love Italy, I'm Italian, but, they're not, maybe the relics and all the beautiful art of Italy, and yes, there's technology, but I think the fact is that I'd love to see a stronger patent system return, and I think that's only going to happen if we can embrace the little guys and those who are out there tinkering and coming up with new ideas, because that's the real audience of tomorrow, are the people and the kids and the students who are out there with the courage to take that huge risk. And so that's where the civility is. And not everybody is an NPE by choice, and we're not trolls if we don't have enough money to manufacture and be in the actual marketplace. So that's something that I just wanted to add. But thank you so much for this amazing day.
Thank you.
Thank you.
And I know we didn't have much time for questions, but there is a happy hour outside, so why don't we move it out to the happy hour spot and you can ask your questions there.
Really?
Yeah.